Hello everybody. In this video I'm going to do a belated video on the sentencing of Christian Eppinger and this one little irregularity that popped up that some people were confused about, and it was exacerbated by the fact that the live stream was kind of quiet at this point, so there wasn't a clear explanation given. But the transcript came out recently, so I can give a better explanation, and I'm going to do that here. The first thing you need to notice, this is Mr. Eppinger's final disposition, his written sentence. And it'll make sense why I'm saying this in a minute. This count 35, there is no count 35. It's not marked as either null prost, as this one is. Null prost just means dismissed, basically. They're not prosecuting it. And there's also no plea. It's just not there. And just to show you that there is a 35 against Eppinger, see here, count 35. Which is possession of firearm by a first offender probationer. Same thing here. This is the re-indictment. Christian Eppinger, count 35. So this is just to show you that there is something going on with count 35, and it wasn't clear from the live stream. I'm going to show it to you now. It's hard to hear, but some of you may have seen it, and I just want to give you a reminder. So here we go.
Possession of firearm, proper within probation. Excuse this one, during the first charge. Count 36.
Wait, back up. What do you mean by the first charge?
During the first series application round of that case. Count
35 was?
Yes, Your Honor. We probably motion to have that count dismissed.
All right.
We put it in the count
All right.
34.
Okay.
Count 36, possession of firearm during the commission of felony.
Okay. So, I mean, I certainly couldn't hear that myself when it was played, but maybe you can. But I have the transcript here, and we'll start with this. So this is Ms. Hilton. She's just reading through the counts and what the disposition is going to be. Count 34, possession of firearm by a first offender probationer. We are null prosing count 35, possession of a firearm, again, by a first offender probationer. Mr. Johnson says count 35 was previously dismissed, so they're not null prosing that count. So it says, oh yes, excuse me, Your Honor. During the first charge, count 36. Judge versus, wait, I don't understand. What are you talking about? So it says, during the first series of the case, Your Honor, that case was count 35. Count 35 was, Mr. Johnson, yes, Your Honor, the defense, we filed a motion to have that count dismissed. It was duplicative of count 34. And the reason he's distinguishing, a null pros versus dismissal is a null pros is in the discretion of the prosecution. It would essentially, a null pros in this context would be the prosecution saying, we're choosing not to charge him with this, go forward with charging him with this. It's part of the deal that he's not being charged for this, whereas the defense attorney is saying, no, you already lost on this. It's not your discretion. You are not giving us anything. You just can't charge this count. And I don't think it was a huge difference in this specific case, but it is a substantive difference that can matter in other contexts. But more importantly, I want to show you why it's duplicative. So I highlighted a few things that I want to show along the way because, I can't help myself. I can't remember which ones I chose this time. The classic. I've shown this one before. Diamante Kendrick. Classic. His name is Kendrick, for those of you who aren't familiar with the case. Let's see. What other ones did I want to show you? Here we go. Criminal damage to property in the second degree. Criminal. Okay, so I think... Oh, is there another one that I want to show you? Yes. This, that, slim shit. This, that, mob shit. Slime, of course. This is just, I guess, implicating... Oh, there we go. This, that, slim shit. There you go. You can see that better now. I don't know if I've done a video on this, but this is Jimmy Winfrey saying F the judge, YSL, this, that, mob life. You should see what the Georgia Supreme Court said about that judge, because they agreed with him. They were very unhappy with the judge to whom he is referring in that song. Yeah, the Georgia Supreme Court they said the same thing, but in judicial speak. So here we go. We're going to go down to count 34. 34 and 35. So, yeah, I'm just going to read through the first one so you get a sense of what it should look like. Or what the charge looks like in this case. So, Christian Eppinger, charged with the offense of possession of a firearm by first offender probationer, 1611-131, for the said accused in the county of Fulton in the state of Georgia on February 7, 2022, after having been placed on probation for the offenses of robbery and ag assault. On the 2nd day of December 2016, indictment 16 SC, in Fulton County Superior Court, did possess a firearm during the commission of a crime against or involving the person of another, to wit, the attempted murder of Officer David Rogers, as alleged in count 32. A couple things here. The crux of 131 is that you are a convicted felon, and at the time of being a convicted felon, you have a firearm. So you need to allege what the defendant's prior convictions are. Saying been placed on first offender probation for the offenses of robbery and ag assault. So those are their prior convictions, and they're saying he possessed a firearm. So that is sufficient to charge 1611-131. However, you'll see down here we have a second count of 131, and the way they distinguish between the two is by including this information here. To wit, the attempted murder of William Johnson. Is a different officer, Officer Johnson. And so, while this part, the attempted murder of Rogers and the attempted murder of Johnson, are not they're not elements of the crime. You don't have to prove that he was using the firearm in a crime or otherwise. You don't have to prove that. You only have to prove that he possessed the firearm. But the way they're distinguishing between the two is by describing what he was doing. For one, they're talking about the attempted murder of David Rogers, and for the second one, they're talking about the attempted murder of William Johnson. Not elements of the crime, they're just distinguishing the two crimes. Now, let's turn to the re-indictment, which is where our many issues arise. So let's go to, sorry for not having this queued up, 34 this time, and you'll see that it is basically the same. Let's see if I can get this a little more. There we go. You can see just visually, one has more stuff than the other one has. The first one, there's just more stuff there. So even if you don't know what any of this means, I'm not going to make a joke about that. You can tell that there's something different, right? There's just stuff missing from this version, which is the operative version. This is the one we're working off of. This one. So they took stuff away. They took stuff out in their second version. They intentionally took stuff out. See, they take out David Rogers. For count 35, let's see if I can get it lined up like that again. Here we go. You'll see that there's just stuff missing a second time for both of these. So they took out the names of the officers. This is not, again, they're not adding them in to fix it in the second version. They're taking them out to break it in the second version. See, this is the first version with the names. David Rogers, Johnson. The second version, the amended version, they intentionally took out the names. Rogers and Johnson. Whoop. That is, I hit S there, not E. There we go. So there are no names. And so the effect of that is, remember, the names were what distinguished the two. They're otherwise identical. So by removing the names, you have just two completely identical counts. Oop. And if you go back to the transcript, you will see the reason for why they were dismissed. Count 35 was dismissed because it was duplicative of count 34. They are the same in this version. 34 and 35 are duplicative in the re-indictment. They were made duplicative in the re-indictment, where before they arguably were not. There's an argument to be made that they were duplicative even in the original, because it was one incident of Mr. Eppinger having a firearm, but it's absolutely duplicative in this second version. So, turning back to the disposition, that is why there is no count 35, because it was previously dismissed. And you can see here, that is what Mr. Johnson is saying. It was duplicative of count 34. Again, 34, 35, they are verbatim reproductions of the other. So that is why Christian Eppinger's count 35 was dismissed. There you have it. That is the end of the video. I'll probably be doing some more counts, looking into some more counts that are in this case that are not particularly strong or particularly compelling. I'll probably do count 63 next. That's one of the worst counts in the entire case. Maybe some of the overt acts as well. We'll see. We'll see how much interest this little series gets. But in the meantime, that is all that I have.